Okay, so I'm gonna stand back here and not out there because I have a cheat sheet on here with notes, so forgive me if I stand back here. So basically when thinking about this presentation, I tried to think about probably the 5 most common mistakes that we see clients make. So these are in no particular order. It's not like this is the most. We're not going backwards from 5 to 1 or 1 to 5, but I think these are all pretty common mistakes. The first is cut and paste contracts. I don't have a problem with clients finding a contract online. Sometimes there's really good forms available online, but I worry when they aren't sure, they're not aware, they don't know exactly what it says, or in a worst case, when they take something from online, they're not sure whether it's applicable to their state, applicable to their situation, and then they start making changes to that. So we see that a lot. We used to call them Franken-forms at my previous firm, because you would establish this form and say, okay, everybody use this form, and then it would be like, well, this sales guy wants to make this change, and somebody over here thought this would be good. So the basics of contracts are kind of an important thing for you and anyone who works in your business to know. You need to understand how a contract is made. You need 3 things to make a contract. You need an offer, whether that's you having your services on your website where people can click and buy them, whether it's having things on a shelf in a store. You need acceptance, where someone says, yes, I will buy that at that price. And then you need consideration. If you're buying an actual physical thing on the shelf, the consideration for me, who's the consumer, is the thing I'm getting. The consideration for the company is the money I'm giving them. So something of value that changes hands. And if you take one of those away, then you don't actually have a contract. But on the flip side of that, there are many ways to make a contract. You can be in a contract and have no idea. You can accept terms on a website. You can proceed to checkout and click the little box that we all click. You can sign a purchase order, or you can accept a proposal, or you can just have a course of dealing with someone. You may not have anything in writing, but it may be that for X amount of time, I have sent you a bill and you have paid it. We may not have an actual contract that actually says these are the terms we'll use, but we had a course of dealing. And then there are also times where maybe you're just trading emails with someone, but maybe those 3 things, offer, acceptance, and consideration, are considered to be in there. So you have to be careful about whether you're in a contract and knowing what makes a contract. You want to make sure you control the terms if possible. If you are dealing with someone and they say, do you want to draft the agreement between us, or you want me to do it? You always want to do it if possible. If you control the terms, you can put things in there. People really need to think about it when they're making a change. They often don't think about it as much when they're reviewing the entire document. But when you're making a change to their document, they sometimes it's not even, I don't like that change. It's, I can't believe you're changing this perfect thing that I've given you. You want to make sure that any contracts that you have for services or goods, that you get yourself paid. You want to make sure that you set a time and consequences if someone doesn't pay you. You want to make sure, I see a lot of clients who have form contracts that they pulled from somewhere and they have net 30 terms in there. And I ask them, do you really want to give an interest-free loan to your customer for 30 days? You don't have to. And then they're like, oh, wait, what? I could, you can make it due in 10 days. You can make it due on receipt. You can make it due in 15 days, but give them a discount if they pay more quickly. There's a lot of things you can do to kind of cut down the time between sending the bill and getting paid. You also want to make sure that if you don't get paid, there are consequences. You want to look into how much interest can you charge? What other things can you impose? Can you contract to say that if I have to take action to collect from you, I'm going to get my attorney's fees paid for. I'm going to get any of my collection costs paid for. Any of my time that has been taken away from what I do to get you to pay me is taken care of. And that's just something that a lot of people don't think of, or that you don't find a lot in forms. And then be clear on what you do and don't include in what you're doing. I see this a lot with web developers. You know, they have to really specify, I'm going to build this site and I'm going to give it to you, but then I'm not your constant on-call person for like, how do I put an email address in here? How do I make a link live? You can add that in. They can purchase your services later, but that's not included in the price of me building this site. So be clear about, this is what I'm doing and this is what I'm really not doing. So those are kind of, you know, the big picture items, the big issues that I see that come up with contracts. The second mistake I see people make sometimes is doing it yourself formations. This chart here kind of shows the 3 most common types of companies you'll form. The bottom one, a general partnership, is normally formed. There is a statute that covers it, but a general partnership is formed by magic if you and another person are out doing things in the world together and holding yourselves out as any type of business. It's the 2-person version of a sole proprietor, and it's not something you really ever want to be in, because partners in a general partnership are liable for whatever the other person does. So I don't know anyone in the entire world that I trust enough that I would want to be in a general partnership with them. So if you are going to work with somebody else, you're going to definitely want to form one of these top 2. And this chart is just something, it's actually a cheat sheet that I sometimes give to clients that shows kind of what it takes to make these different entities. And we're going to talk a little bit more about that on this slide. So you've decided, I don't want to be a sole proprietor, although being a sole proprietor is fine. I mean, if you do something that you don't anticipate having a lot of risk and liability, if you don't really see any, you know, your tax person that you've consulted with says there would be no tax benefit to forming a company, there's nothing wrong with not forming a company. But if you're doing business with someone else, or you're doing something, or you're getting enough business that you think, okay, there's a chance that I could get sued, or someone could be unhappy, or I have a fair amount of personal assets that I want to protect, you're going to want to form some type of company. So basically what you have to do, the only thing you have to do really, the only thing you have to do is file documents with the Secretary of State to form a legal entity. You file articles of organization if you are an LLC, and articles of incorporation if you are filing a corporation, and it is $20 more expensive to file them online than in the mail, which I don't really understand, because then someone has to like actually physically open them, but maybe that's like job security. Maybe the people at the Secretary of State were like, you can put this online, but we're gonna have to charge more. So that's really all you need to form a company, and that's the biggest mistake that I see a lot of companies make. They do that, they file, you can log on and file yourself, and then that's it, they stop there. There are other documents that you need to have that don't get filed anywhere, that don't get filed with the state, but that you should have for various reasons. One of those is called a contribution agreement if you're dealing with an LLC, or a share certificate if you're dealing with a corporation, and that proves that you own the business. Just by signing the incorporation or organization documents, you don't own the business. And a lot of bankers and other people will do this incorrectly. If you sign as the organizer, they'll let you go open a bank account, but that doesn't really prove that you own the business. Records of action or minutes are things that will say who's on the board, will say who is fulfilling the following positions, the officer positions that are required by Minnesota law. And then an operating agreement for an LLC or bylaws for a corporation are kind of the rules of the road. And those, if you are in business with more than one person, you definitely want to have these things. You want to make it clear who does what, who owns what portion of the company, and then how decisions are made. You know, the operating agreement and bylaws say, you know, this is how we'll make decisions. This is how much of a voting interest we need to make certain, you know, to sign checks or to spend money or to dissolve this company. It's really, you know, kind of vital information, and there's no default for a lot of things. Some things you'll be defaulted into if you don't create these documents, but other things there's just not a real filler for it, and they don't become a problem until you realize you don't have them. This is kind of the third issue that goes hand in hand with the other, is the thinking that we all get along. This is particularly for people in business with more than one other person. or one other person. Basically, if you have, a general partnership, an LLC, a corporation that has more than one owner, there's definitely another document that you should have. And that's called a member control agreement for LLCs or a buy-sell for corporations. And this is basically, the prenup and the will for the company. This is the heart and soul of, this helps when there's a dispute. This sets out, what's gonna happen if someone dies? What's gonna happen if somebody wants out? What's gonna happen if somebody gets divorced and their spouse tries to take an interest in the company as part of the divorce settlement? And I always tell people, you probably don't want to be in business with your business partner's kids or happily married spouse, but you definitely don't want to be in business with your business partner's soon-to-be ex-spouse. That's something you want to avoid at all costs. So having this member control agreement or buy-sell kind of sets out, well, what will happen then? If somebody dies, their heirs don't have to just inherit the company, we can buy them out. And this agreement sets out, well, how will we do that? And how will we value the company? And how long do we have to pay it out? And you can kind of dictate all of that. You can decide. If you're in the early stages of a business, you might not have the cash flow to buy someone out just right on the spot. Because even though you're not making a lot of money, there may be a lot of potential in the business. So I basically, when we have a client walk in the door and there's more than one of them, they'll be saying, well, we want to do this and we want to do this. And most of the time what we tell them is, we need to slow everything down and you guys need to get some sort of agreement among you. Because in the beginning, you do all love each other. Like everybody's like, we're going to be in business forever together and we're going to make millions of dollars and it's going to be great. And then you start working and it's like, this person never comes to work. I do this all. I put in more money. I can't stand this person. And sometimes when there's two of you, you may own the business 50-50. And so what happens then if you just can't get along? There are provisions you can put in for that. There are different ways you can kind of get rid of someone without having to take the entire company down. So I would say, I found it interesting in the earlier presentation about the percentage of businesses that survive after certain things. I have seen a lot of businesses that did not survive just because they were missing kind of this important document that would have allowed them to just, not happily, but at least more easily get rid of someone. This fourth point is about confidentiality. You can't always prevent, especially in a small business, the people that you work with from having access to certain information. I mean, you may all work in the same room. You may all work on the same computer. It's really hard to kind of keep certain information from people. It's really hard to keep your trade secrets. It's not like any of us have the formula for Coke and we're like, have a big enough company that we're like, no, only 2 or 3 people need to know this. So in your company, once you start having other people work with you, you want them to agree to confidentiality from the start. You want to get them to sign an agreement that basically says, anything you learn here or anything that you find out about our business or our clients or our methods, you're not going to go tell them to anyone else. You want to make sure you can stop them before they tell. We see people sometimes who come in and say, well, this person divulged this confidential information or used this confidential information. And once they've done it, there's not a lot of, it's kind of hard to prove the damages. So you want to make sure that these documents that you have people sign have protections in there for injunctive relief that basically say, if I think this person is going to violate this, or if this person basically threatens me and says, well, if you won't do X, Y, or Z for me, I'm going to go, let people know we're planning to expand or take your customer list. You want to be able to go to a judge and say, we want to get an injunction to stop this person from doing this. That's kind of a vital piece that a lot of confidentiality agreements don't have. And then you don't just want it to be the people that are working for you. Some people are like, well, I'm so far removed from when I'm ever going to have other folks working for me. Think about people you're talking to about your business or about your idea or about what you're going to do before you start it. And that's another area where people will come in and say, I need to set up my company and I need to do this and I need to do that. And sometimes the very first thing they need is just a really solid NDA, because they're out pitching people because they're trying to gauge interest. They're trying to see if a prototype can be built. They're trying to get funding. And so, you know, if they're out discussing this with lots of people who have no obligation of confidentiality to them, the most important thing before they form the company may be, let's just get all these people to sign an agreement. And I never mind. I mean, clients sometimes, I'm very happy when clients come in and are like, I want you to sign this confidentiality agreement. It's like, well, nothing can be more a higher duty than my duty as an attorney, but I am happy that you are out there making people sign this. And then this is a huge issue, whether someone's a contractor or an employee. When you're first hiring someone, it's so much easier to just have them fill out an independent contractor agreement or to just start paying them money in exchange for the work they're doing. But it does matter. I normally hear from people like, well, I'm never going to get audited by the IRS. And I mean, if they're playing the odds, they're probably right, because very few businesses get audited. But it's not only the IRS who cares about whether you have someone misclassified as a contractor or an employee. The state, particularly the state unemployment office, really cares. The State Department of Revenue, which is smaller and has an easier beat on you because you've signed up your company, really cares. And particularly if you're not big enough to have your workers' comp insurance, if you have workers' comp insurance through an individual insurer, you will get thrown into the state pool, which is just kind of a bunch of small businesses. They really care whether you have someone classified correctly. And so a lot of these companies will, or these organizations will come in and will just say, we're gonna do an audit and we're gonna see if these people are classified correctly. And unfortunately, each entity kind of has its own checklist of what is or isn't. I mean, if someone could create just one, if they'd all get together and say, all right, if you hit 7 of these following 25 things, you're an employee, it would be wonderful. But each entity has their own method. You know, the IRS has some publications where they say, well, here's the factors we take into account, but some of them are more important than others, and we're not going to tell you which is more important. But normally, you know, you want to look at, is the person doing something that's a particular skill? Or is it a job that pretty much with a tiny bit of training, a day or two of training, anyone could do? Do they have control over when and where they do it? You know, do they set their hours? Do they come and go as they please? Could they do it at home? Could they do it where you are? And do you have say over that? Do you provide them the tools, or do they bring their own? You know, do they have to bring their own computer and things like that, or do you provide it to them? And then who sets their schedule? You know, are they kind of punching in and punching out and taking set lunch breaks? And how long's the term? You know, if you hire someone seasonally and they're doing something that's really skilled and you really don't give them a set hours, you just say, I need this done by whenever, then you probably can err on the side of an independent contractor. You also want to know, do you have an agreement with them? You know, you want to make sure that if you are hiring someone as an independent contractor, you have a very clear agreement that says, we're hiring, you're an independent contractor, and here are the things we're not going to do, and here are the things you're in charge of. So you make it very clear. So they can't later say, oh, I thought you were withholding for me. I didn't know I was supposed to pay these taxes on my own. And then actually, back here, one point about this confidentiality business is, if you are hiring an employee or a contractor, but this is most important with employees, if you're hiring them and you know you're gonna want them to sign a confidentiality agreement, or you're gonna want them to agree not to solicit your clients when they leave, have them do that at the beginning. Make their hiring, make their offer contingent on them signing this, because you can get it down the road. You know, a lot of people are like, well, I wish I'd talked to you before I hired this person, but then you have to give them some form of consideration. As you remember from our very first slide, you need that consideration. So you will have to pay them, or you will have to give them, you know, paid time off, or you will have to work out some arrangement that is pretty substantial if you didn't kind of say, I'm offering you this job, or I'm offering you this position, or I'm offering you this contract. This is one of the contingent terms of that. So you want to make sure that if there are people working for you who you're going to have sign something like that. You're going to say, please don't steal my clients, and please don't, take our confidential information. Have them sign it at the very beginning. So that's about it. You can reach me via email there. There are 3 attorneys at our firm. Joe, who's one of them, is back there. We have locations in Uptown and Downtown. And if you guys have any questions, yes?
Yes, I sent out an email, and the heading, I said, how is your corporate veil? Could you explain piercing the corporate veil as a security issue?
Sure. So when we talked about forming companies, people talk about piercing the corporate veil, or you can pierce an LLC veil as well. But basically what that means is when you set up a company, it's a completely separate thing from you. As long as you don't personally guarantee contracts that the company's getting into, you aren't responsible for them. That people can only look to the company to get that fulfilled. They can't look to your personal assets. But if you don't follow corporate formalities, if you don't keep your money separate, if you don't have some of these things done, if you don't have records of action or minutes from meetings, if you kind of treat the company just as your own piggy bank and mix and mingle things and don't keep it in existence, because once you form, it's not too hard to form a company and create this liability shield. It is harder to keep it going because you have to renew it every year. There's no fee unless you forget, but there's a lot of things you have to do to make sure you're staying in compliance. And if you don't, and someone wants to sue the company, but really actually wants to sue you because they want you to be responsible for it, they'll just make an argument that this company wasn't really a company. We should be able to go right through this corporate veil and get right to that person's assets. And if you are a single member company, you want to think about that, because it's an argument it's the first argument that people will make, because otherwise they'll sue you, and if your company, doesn't have a lot of creditors or asset, you'll just close the company down and start a new company. And they won't have anything to collect against. But if they can get through the company and get to you, they've kind of taken away that liability protection, which is often the main reason that you formed that company. Yep. Any other questions? Yep.
I used to be in the banking world, and I see a lot of these one-person companies, a landscaper type deals, and they would try to maintain a separate business and personal account, but they just didn't have a ton of money, and so ultimately it's just like you would see they didn't even have a personal account anymore.
Right.
And McDonald's, groceries, everything went. And I get ultimately they can get their tax preparer, CPA, whatever, to get that all done. But would that be something as simple as that? It seemed like they just use it.
Yeah, I mean that's one of the first things you'd look at to say you don't even have a personal account, so you're just using this company account as your own. You should always, even if they have it at the same bank, and they can just transfer back and forth, that's fine, but you want them to have it separate. And that's something that most good tax preparers will really catch when they bring it in and say, well, can you just separate out the business stuff? They'll say, no, you really need to have a separate. Well, and the interesting thing is a lot of those, landscapers and things like that, sometimes they've only created the company because, back to the workers' comp people, in Minnesota, in a lot of states, but it's in Minnesota as well now, workers' comp is one of the areas where the state is kind of cracking down. And so the state has said for certain industries, and I don't know if landscaping fits under it, but a lot of the trades, kind of building, roofing, interior construction trades, they said if you hire people and they're individuals and they don't have their own company, then we're going to assume they're employees. You can't basically make them independent contractors unless you jump through all these hoops and have all these filings. So what happened was, it wasn't like, every general contractor then was like, I will do what is right and make these people my employees. What they basically did was say, you all have to go out and form an LLC. So there's a bunch of single member LLCs where no one is really observing corporate formalities because the individual doesn't really care whether it gets pierced. They just want to keep working.
That's exactly what they did, because nobody has their vested interest in heart.
Right.
Out of the banker world, the bankers would go on the SOS website and sign them up, and here you go, and boom, they met a quota for the day, and that person thinks they're all protected. And
Right.
it's like,
And LLC can still fail the contract test.
Yeah, well, yeah, it certainly can, but it helped. It was, in the beginning, the state was like, well, yeah. Yeah. But yeah, that's certainly an area. I mean, when you're thinking about contractors versus employees, you know, a good thing to think is like, if this person no longer has this job, or if this person gets injured at this job, are they gonna think they're covered? Are they gonna think they can go file for unemployment, or think that they should get workers' comp? Because if they do, then you probably need to reassess. Any other questions? Are we ready with ADT? Are we ready?